The Supreme Court speaks again on another 2A case that was highly anticipated. We were waiting to see whether the Supreme Court would take the Antonyuk versus James Sensitive Places lawsuit out of New York. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are back on the SCOTUS watch as we see another 2A case on the order list coming out this morning on Monday. To talk us through that, we have brought back volunteer president of CRPA, that is Michel. Chuck, thanks for being on with us today.
Always a pleasure, fellas. Thanks for having me.
Yeah, absolutely. And guys, before we get into this today, please, it continues to work. Be sure to like, share, and subscribe to these videos. It really helps the information get out as far and wide as possible. While we've got this ball rolling forward with the 2A movement in California, we're looking to make sure and give it as much momentum as possible. You can help contribute to that by liking, sharing, and subscribing. So please go ahead and do that. So Chuck, often we say no news is good news. Can't really say that for the SCOTUS watch here as we continue to see cases like the Snopes and the Ocean State Tactical lawsuits sit off of these order lists. However, the one that came out this morning we noticed under the denied section was the Antonyuk place. For those who haven't been following along, this is a case that we have been following. Chuck, can you give us just a little bit of a preview? What was the Antonyuk case coming out of New York, and what was its path all the way up to the Supreme Court?
Well, that was a sensitive places case. Remember, in all the jurisdictions that don't like Bruen, California, New York, Illinois, they're doing everything they can to make a permit to carry a firearm in public useless by making it invalid in as many places as they can by falsely designating those places as sensitive, because the Supreme Court in Bruen said that jurisdictions, governments could ban firearms entirely in certain sensitive places, but they meant like courthouses where you're behind a metal detector, or airports, things like that. The city of New York would like to designate the entire island of Manhattan as a sensitive place. And that's the games that California and New York and Illinois have been playing. And CRPA has a lawsuit challenging California's false designation of too many places as sensitive so they could ban guns there. And by the way, remember, governments routinely prohibit firearms from being possessed in public unless you have the CCW, the carry a concealed weapon permit. But it's been very rare. For 100 years, they didn't ban possession of firearms in any place if you had the concealed carry permit. So now they suddenly, 100 years later, decided that, oh, we can't let people with these permits carry them there either, even though there's never been a problem. It's all a pretext to just try and make CCWs useless. So in New York, they banned these firearms in multiple places. And as has been our practice and the practice of other lawyers advocating for Second Amendment civil rights groups, we move for a preliminary injunction. And often we win. In the sensitive places cases, it's usually been sort of a mixed bag. They try and designate all these different places as sensitive, and they win some, they lose some, and ultimately the Supreme Court's going to have to say, they'll say, okay, you can't have a gun in a bar, you can't have a gun in a church, or on a subway. And sometimes in some of these cases, the courts have said, no, that's not truly a sensitive place, but maybe this other, in a church is. So we're litigating all these specific areas. In the Antonyuk case, they got a partial preliminary injunction. They appealed the parts that they did not prevail on. But again, our practice has been, and the practice of all the other Second Amendment practitioners across the country has been pretty much up till now, seek a preliminary injunction. But the Supreme Court has now made it pretty clear that's called if you win or lose on a preliminary injunction stage, you go from preliminary injunction to permanent injunction. That's what you ultimately want. And a permanent injunction results in a judgment. When you've got a judgment, that's the end of your case in the trial court, and that's what you can appeal. But you can do what's called an interlocutory appeal of the preliminary injunction too, whether you win or lose. The state can appeal, or you can appeal if you lose. So Antonyuk was up on a preliminary injunction. We were very hopeful that they would take it anyway because there's all these sensitive places going on all across the country. But it looks like the Supreme Court is doubling down on they're not wanting to take cases that are up on interlocutory appeals from preliminary injunction grants or denials. And so that's why we feel better about our decision in the May case, CRPA's CCW sensitive places case, that we did not even seek a preliminary injunction anymore because it's come to the point where even if you win on a preliminary injunction, now the games that the states are playing is they try and repeal the law so that you deprive you of, so you can't recover your attorney's fees as a prevailing party. So you have to get that judgment. And that's how the game has changed recently because of some of the Supreme Court rulings on when you are a prevailing party and when you're entitled to fees. So now everybody's going for a judgment. So anyway, that's the long procedural history of why Antonyuk was probably turned down. Now we still have.
You definitely made that clear, Jacob. If we could pull up the X post from just a couple of hours ago, you actually we've got you quoted here saying this: breaking. We're extremely disappointed, although not surprised, that the Antonyuk sensitive places case out of New York was denied cert today. While we are aware the court disfavors interlocutory Second Amendment cases, we are hoping they would make an exception given the prior GVR in Antonyuk. This unfortunate outcome does at least tell us we were probably right to not seek cert in May v. Bonta, which you just referred to, and instead pursue the final judgment. We will still be doing amicus briefs on the similar Wolford matter, which is the sensitive places case out of Hawaii, although we are clear-eyed about its odds. And then meanwhile, still nothing from SCOTUS on whether they're taking Snopes or Ocean State Tactical. Fingers crossed. I guess a couple of things here. And Jacob, perhaps you can do this. Guys, if you haven't been following along on the May v. Bonta lawsuits, there's a lot of information already on YouTube. Jacob, maybe you could post the last couple of videos that we did, just sort of clarifying its path through the Ninth Circuit. What is still has an injunction on it and what doesn't, because there are like individual things there. But Chuck, you kind of, just to reiterate, the decision making on May to seek judgment sort of looks like with Antonyuk being denied was the right call. Although I am curious about this one thing. You were hoping that they would make an exception given the prior GVR in Antonyuk. What is a GVR and how would you have hoped that affected this?
Well, GVR means this case was up to the Supreme Court once before. So they've seen the case and they sent it back down and said, hey, pay attention, Second Circuit, New York Circuit. Listen to what we said in Bruen and apply it faithfully. Well, the Second Circuit didn't. So we thought maybe because the Supreme Court had already basically ruled on. So what happens is you ask for cert, you file a petition for a writ of certiorari in the United States Supreme Court. That means you're asking the Supreme Court to review the case, the appellate court decision. It takes 4 votes, 4 Supreme Court justices have to vote to take a case, takes 5 votes to win. So they held that case while Bruen was pending. Then when Bruen came down, they granted cert, but rather than having a whole oral argument about it, they just vacated the lower court judgment and remanded the case back down to the Second Circuit. Grant, review, vacate the decision, remand, GVR. That means they said, hey, you look again, guess again, based on what we said in Bruen. So there had already been that up and down between the Supreme Court and the Second Circuit. We thought that boded well for the Supreme Court wanting to see it again because they had basically admonished the Second Circuit to pay attention to Bruen, which they didn't really do. So we were hopeful that the second time would be a charm, but unfortunately it wasn't. But that just means Antonyuk goes back down to the trial court, and there will be a judgment, there will be evidence, there will be a trial, and then ultimately a judgment, either in our favor or against us, or partially with us and partially against us, and then it will work its way back up again. In the meantime, there are other sensitive places like CRPAs in California. And I mean, these are all the main issues: sensitive places, undue delays and high fees for a license to carry, semi-auto bans, standard capacity magazine bans, anything that holds over 10 rounds they want to ban. And so all those cases, and so we've got the Seventh Circuit is looking at the semi-auto ban in Illinois. We've got two cases in the Ninth Circuit on the semi-auto ban. We've got Duncan, which is a very promising case because it's been tried twice. So it is fully developed. It's fully baked, so to speak. And that is now going to the United States Supreme Court. That's another CRPA case, which
Well, that was
creditors deserve.
kind of where
NRA has been helping to fund a little.
that's kind of where I wanted to go with this. You know, I remember when was it? Back in 2022, there was like a palpable tension that kind of led up to Bruen. Do you feel like that's kind of building again now? We've got several cases that the community at large feels are viable to, you know, really help straighten out the way that Second Amendment cases are ruled on in this country.
On some of the major issues. And all of it ties back to the Bruen methodology and whether the courts are faithfully adopting the testing in the way that Bruen said it should be done. And most of them aren't. And so the Supreme Court is certainly aware. They've been made aware multiple times, and they can see it for themselves, that the lower courts are playing games. They know they've got to straighten it out. Whether they do that in Snopes, which is the semi-auto ban that we're still waiting to hear whether or not the Supreme Court will take, or Ocean State Tactical, which is the magazine ban, but Ocean State Tactical is a preliminary injunction too. We don't know, but they haven't decided on that today. So we'll be looking at it again next week. Next Monday, we'll be talking again about whether they take one of those. But it'd be nice if they did, because it would save us time on Duncan or Rupp or Miller or all the cases, Rhodey, our ammo case, all those cases that are in the Ninth Circuit. If the Supreme Court would just make clear to these lower courts how the Bruen test is supposed to be applied and then make them do it, we could save a lot of time with our cases, because their decision would clarify how things are supposed to be done in our cases. But we'll just have to wait and see.
Yeah, and that's certainly the hope, is that they would take a case sooner rather than later to get that clarification. So I guess with that said, what are your final thoughts on here for the Supreme Court of the United States moving forward? How many more conferences do we have before the session ends, and what's it look like moving towards that?
Well, their session ends in June. They typically have conferences every week, depending on how many cases they have pending. Some of those conferences are more substantive than others. So they have a few more before the end of the session. But at this point, if they take a case, it wouldn't be heard until the next session, which begins the first Monday in October. So it'll be a while no matter what happens. But they could GVR Snopes. They could GVR Ocean State Tactical. They could, who knows? But at this point, there's been so many postponements on Snopes and Ocean State Tactical that it may be that someone's writing a dissent on why they are not taking, why four justices have not voted to take the case. And that would be Thomas or Alito probably would be saying, because Thomas and Alito are acutely aware of the fact that their opinion in Bruen is being twisted by the lower courts, and they want to straighten it out. But remember, the Supreme Court right now has its hands full with all these Trump preliminary injunctions on the scope of Trump's executive authority, and saving money on fraud, waste, and abuse in the federal government, and all the states like California that are trying to stop him from shutting down programs that are a waste of money. So they're looking at a lot of interlocutory appeals. If you're the president of the United States, it gets a bit more likely that they will take an interlocutory appeal, sure, even though they don't like them generally.
Well, certainly a lot to look forward to. And guys, don't forget, I mean, just one organization here. We've got the B&L Productions going to the Supreme Court. We've got Duncan that's headed to the Supreme Court. We've got cases that have been held up with Duncan that are going to start moving at the Ninth Circuit. So a lot of movement there, a lot to look forward to, which, Chuck, I'm sure keeps you and the attorneys plenty busy. So I do appreciate.
Let me just say, I know, with the stock market doing what's doing, everybody's worried about the 401k plans. If we need help. We give very generous discounted rates to the CRPA as a nonprofit, but it still takes money and time to litigate these cases, and we can't give up. We cannot give up now. This is a historic time for the Second Amendment. We are going to get some historic results that are going to make a difference for ourselves and for our children and our grandchildren. So we just have to keep fighting. We need your support. Help us out if you can. It's greatly appreciated, and we will put it to good use. Okay, we have a Doge inside CRPA that makes sure we don't have fraud, waste, or abuse going on at the CRPA, and your money is well spent.
Well, absolutely, and we appreciate the time. I know that you're a busy guy. I want to thank you for coming on and shedding some light on this for us.
Thanks for having me, guys.
Absolutely. And guys, if you want to continue to see content like this, please, as always, be sure to like, share, and subscribe to these videos. It's a great way for you to directly contribute to the Second Amendment litigative and legislative movement here in California. Thanks again, guys, and we'll see you on the next one.